Resuming debate, Senator Kutcher.
Thank you very much, Speaker. Now I will continue. I was just saying that this is a difficult task we have as we seek to balance what we consider to be just and right with what we understand that the Charter has framed. And it's not easy. I come to this challenge with the added perspective of a psychiatrist who has for about 4 decades served to try and alleviate suffering experienced by persons who have a mental disorder in Canada and across the globe. I've seen discrimination and violence against those whose mental disorders are considered not to be real illnesses, but an expression of a demon-haunted world or a demonstration that the person suffering is less than human. I know the strengths and weaknesses of the treatments that are available for mental disorders, and that their effectiveness is not substantially different from that found in all of medicine. I know that many people with a mental disorder will get better, but I also know that a small number will experience a grievous and irredeemable chronic course despite trying every treatment available to them. And I know that the suffering of those who have mental disorders is no less real or no less painful than the suffering of those who have any kind of severe chronic and life-destroying brain disorder. We know that many people with a mental disorder have been relegated to second-class citizen status, and this is not okay. That they have been assumed, because of their mental disorder, to not have the capacity to live their lives as they see fit. And this is why I find the exclusions of mental illness as the sole reason for provision of MAID in C-7 egregious. It does not treat people who have a mental disorder equally before the law. We know that having a mental disorder may, but does not necessarily, impede rational decision-making at some time during its course. And we know that a person can both have a mental disorder and be fully competent to make complex decisions about their own life. That a competent person, with or without a mental disorder, has the right to choose how they conduct their life, even if we disagree with that choice. Their autonomy supersedes paternalism. And we, as a society that values individual autonomy, understand because someone disagrees with their choice does not mean that the person making that choice is incapable of making it. Simply put, a person's capacity and their right to choose are not dependent on what others think of their choices. If permitted by law, it is the right of a competent person who has a grievous and irredeemable mental disorder to be able to choose how they live. And based on the same logic, I think that it is the right of a competent person who has a grievous and irredeemable mental disorder to be able to choose how they die. However, the individual making their choice must be competent to do so and must be provided with appropriate support in their decision-making. Highly trained health professionals, following careful, considered analysis, are able to determine if an individual with a mental disorder does or does not have rational decision-making capacity. Indeed, psychiatrists, geriatricians, family doctors, and others are frequently asked to apply these evaluation skills to determine if this is the case in legal and in therapeutic situations. This brings me specifically to the Mental Illness Exclusion Clause and its accompanying charter statement. It reads, for the purposes of paragraph 2A, a mental illness is not considered to be an illness, disease, or disability. This clause subordinates the reality and richness of an individual's life into what is a faceless and potentially stereotyping category that is then used to define what a person is deemed to be. Bill C-7 substitutes a diagnosis for a person. This is dehumanizing. This bill assumes that people who have a mental disorder do not have agency, that they do not have decision-making capacity, and that they cannot determine how they will live their lives or how they will choose to complete their lives simply because they have a mental disorder. It perpetuates centuries-long stigmatization of those living with mental disorders as incompetent and incapable beings. And it ignores that the request for aid is based on a competent person's decision that their suffering is unbearable to them because of their grievous irremediable disorder. It is the result of the totality of their experience, not based on the diagnosis. C-7 would, however, allow for aid provision to persons who have both a physical illness and a mental illness, even if the mental illness is the predominant cause of the suffering, but not for those who have a sole irredeemable mental illness. And it makes a healthcare provider who has participated in aid for a person with a sole mental disorder a criminal, while at the same time it respects the professionalism and competency of a healthcare provider who has participated in aid for a person who has both a mental disorder and another illness. This is indefensible. The Charter Statement defines a mental illness as a condition that is primarily within the domain of psychiatry. In my over 40 years of practicing medicine, I have never heard an illness defined in that way. Yet, the reality is that perturbations in function of the brain and the nervous system, be they classified as disturbances of emotion, cognition, behavior, movement, or any other brain function, are treated by many different healthcare providers, including, but not limited to, psychiatrists, neurologists, neurosurgeons, neuroradiologists, family doctors, nurse practitioners, pharmacists, and others. And similar treatments are used for different classifications of brain disorders. For example, epilepsy and bipolar disorder can both be successfully treated by the medications carbamazepine and sodium valproate. And these different classifications often coexist. For example, major depressive disorders occurs frequently, perhaps in about up to 50% of individuals with Parkinson's, Huntington's, and Alzheimer's. The Charter Statement then argues that the exclusion is based on the inherent risks and complexity of aid for persons who suffer solely from a mental illness. However, there is no unique or different inherent risk of complexity for mental disorders than that found in any chronic brain disease, including the certainty of cure, the effectiveness of treatment, and the risk for suicide. First, there is no cure for many chronic brain conditions, such as Parkinson's, Alzheimer's, schizophrenia, bipolar. Second, treatment for these disorders serves primarily to decrease symptoms and to improve functioning. And treatments for mental disorders are equally as good or equally as poor as those for all chronic brain diseases. Third, the presence of a severe and chronic illness is, by itself, an elevated risk factor for suicide. This elevated risk is not only found in persons with a sole mental disorder. For example, the Canadian Community Health Survey found that in young adults, attempted suicide was 4 times higher in those with chronic illnesses such as asthma and diabetes. Suicide rates in persons with cancer are twice as high as in the general population and 8 to 10 times higher in persons with Huntington's. The statement continues that for mental disorder, and I quote, evidence suggests that screening for decision-making capacity is particularly difficult and subject to a high degree of error, end of quote. In the field of medicine, there is no such thing as screening for decision-making capacity. What highly trained clinicians conducting decision-making capacity analysis do is not screening. On the contrary, decision-making capacity is determined through comprehensive and careful analysis that includes cognitive and emotional aspects, as well as the determination of suicide intent. In addition, the assessor continues the social, family, and other pertinent factors, including the treatments provided, treatments that yet could be provided, and the individual's willingness to engage with any further treatment. Furthermore, there is no substantive evidence to conclude that a properly conducted competency assessment is subject to a high degree of error. There may be disagreement amongst clinicians who are assessing patients with a mental disorder and considering for aid, as happens in all medical diagnostic ascertainments. But disagreement is not error. Disagreement is disagreement. And in the one study that addressed this issue in the Netherlands, found that disagreement occurred in 12% of cases. That means that agreement occurred in 88% of cases. This statistic is comparable to the clinical diagnostic disagreement in a variety of brain disorders. Diagnostic disagreement is not unique to, nor of any greater magnitude in, mental disorders. The statement goes on to argue that the prediction of outcomes for persons with mental disorders is significantly below that for other chronic brain disorders. But we do not know that to be true. To actually support this argument, a substantial body of evidence based on multiple prospective studies comparing outcomes for individuals who have a mental disorder to individuals with other chronic brain disorders is required. Then, based on that data, it is necessary to develop algorithms that demonstrate significant differences in outcome prediction for individuals amongst different disorders at different points in time during the course of those disorders. To my knowledge, and boy, I have looked, no such studies and no such predictive algorithms exist. The statement then concludes with an observation that increasing numbers of cases of MAID have occurred in the Benelux countries and that there is a wide range of mental illnesses in respect of which MAID has been provided. This suggests that if MAID was available for Canadians with mental disorder as a sole condition, it would open the floodgates to MAID, that very high numbers of persons receiving MAID would have a sole mental disorder. Yet data from these countries, collected for over a decade, shows that this feared tsunami has not occurred. The range of illnesses involved argument is a red herring. There is a wide range of physical illnesses for which people access MAID. There's no significantly larger or significantly smaller range of mental compared to physical disorders in the application of MAID. Yet the wide range of physical disorders in MAID raises no concerns in the charter statement for C-7. Perhaps yet another stigmatization directed towards those who have a mental disorder? Honorable Senators, I understand that with the mental illness exclusion clause that the government may be seeking more time to conduct a review and determine how to ensure that a fulsome process for those seeking MAID for a sole mental disorder. It does not mean that I agree with that reasoning, and I'm not certain that such a review would occur in a timely fashion. I also do not condone the stigmatizing language used in the clause, nor accept the charter statements that have been provided to justify this exclusion. The bill that has come from the other place includes an amendment that applies an additional safeguard in MAID assessments. This provides greater comfort, and I am pleased that this is now in the bill. In addition, however, I maintain that a further amendment is needed, a sunset clause that would remove the existing mental illness clause within a reasonable period of time. This could be considered during committee study. During the sunset period, the government could put into place all the reviews of this issue that it wishes. Furthermore, a sunset period will allow national, medical, and nursing professional organizations time to create an accredited, interdisciplinary education and training program in MAID assessment and delivery. This would help ensure that every Canadian, regardless of place of residence, could reliably receive a similar quality of MAID assessment and delivery. Honorable Senators, thank you for taking my remarks into your considered deliberations as we all work to better understand and address Bill C-7. We are engaged in a difficult and challenging task. If there ever was time for sober second thought, that time is now. Merci et miigwech.
Senator Kutcher, your time is up, and we have senators who would like to ask questions. Would you like to request 5 more minutes to answer the questions?
Please, Madam Speaker.
Is leave granted?
Yes.
Thank you. Senator Simon.
Thank you very much, Madam Speaker, and thank you very much, Senator Kutcher, for that beautiful and important speech. I'm grateful that we have you as a psychiatrist here because I have a question that I really want. This isn't a political question. This is a the question where I'm legitimately seeking information. Bill C-7 doesn't define mental illness. There are all kinds of conditions that are physiological, neurological, biochemical conditions that cause symptoms that we would classify as mental illness. Someone who has an epileptic seizure might be prone to develop post-ictal manic psychosis. Somebody who's had a head injury or a frontal lobe tumor or the beginnings of Lewy body dementia might exhibit behaviors that are mental illness. So is there such a thing as mental illness? What is the difference between a psychiatric illness and a neurological illness?
The way that that's an excellent question, Senator Simons, and I'd be happy to spend the next 6 or 7 days discussing that with people, but I don't think that's going to be possible. But let me just try to be as concise as I can. What we understand now, and I have to say now because our understanding changes, because the nature of science is that it changes over time as we get better understanding. As we understand now, what we call mental disorders are perturbations of brain function in the cognitive, emotional, behavioral areas of our lives. And that these perturbations are out of the range of normative on various scales and measurements that we use, and they cause substantive functional impairment, and that they are associated with a host of other difficulties in a person's life, so that they have major negative impacts on life. That's how we would understand it now. It was understood differently centuries ago and decades ago. It may be understood differently in the future, but right now that's how we understand it. So the difference, say, between Parkinson's disease and about half of Parkinson's patients will have a major depressive disorder. It shows that it is the problems with the circuits, the brain circuits, the chemistry in the circuits, and those circuits are that way because of genetic reasons. They are that way because of environmental reasons. A head injury can cause damage to different parts of the brain, which then change the way that the circuits operate, leading to a mental disorder when there may have not been one previously. So it's an incredibly complicated area. And I think that the problem with the bill is that it calls something a mental illness without ever defining it. So we really don't know where the parameters are. But it is able, because of that problem with definition, it's able to exclude all sorts of people on the basis because they may have seen a psychiatrist. So if you have hypothyroidism and you have a profound depression because of your thyroid disease and you happen to be treated by a psychiatrist, would this bill exclude you?
Thank you very much.
No?
Well, I mean, I guess my only supplementary question is, do you think it's a legitimate line of demarcation? Is there a hard border between what is a mental illness and what is a physical illness, such that it is reasonable to exclude an entire class of people from the legitimate exercise of a constitutional right?
In my opinion, Senator, we still suffer from centuries of alienism, in which people who had what we now call mental disorders were shut off and put away from society, where they were chained, where they were put into institutions, where they were kept out of sight. And that was in the most severe disorders such as psychosis. And we have gone past that alienist traditions. We are now moving away from silos, away from looking at people as only what their diagnosis is. And we are trying to understand people holistically. We're trying to understand the issues that they face. And so I think that a more modern approach to this would be to call it a mental disorder and to look at it from that perspective.
Thank you very much.
Senator Lankin.
Thank you, Madam Speaker. Senator Kutcher, would you take another question?
Certainly, Senator Lankin.
Thank you. Thank you for your remarks. I think let me say thank you to Senators Seidman, Saint-Germain, and Wallen as well. All of this contributes to our ability to think through these difficult issues. But I appreciate hearing from you because of your professional expertise and experience in both practicing and in research. You talked about the ability.
Senator Lankin, I'm sorry to interrupt again. Time has expired again. Senator Kutcher, are you asking for another 5 minutes?
If it pleases the Senate, yes.
Is leave granted? Please continue, Senator Lankin.
Thank you, and thank you, colleagues in the chamber. You talked about consent to treatment, capacity to consent, I guess, and I appreciate and understand the remarks you made there. At one point in time, you also talked about suicidal ideation, and in this, I get somewhat confused because there are examples that we all know of major depressive disorders and other circumstances where people experience a desire to commit suicide, and yet I've always rejected the phrase, right to suicide. It's right to medical assistance in dying, and they're different. And I'm just wondering if you could explain a little bit more about are we at risk of creating conditions for people who may be, because of their illness, seeking to commit suicide, making use of the MAID provisions from this bill and from the previous C-14. Thank you very much.
Thank you for that excellent and erudite question, Senator. I think that sometimes the language that people use confuses others. So when we use physician suicide or assisted suicide, it assumes that suicide and medical assistance in dying is the same thing. It's not. As someone who has worked with people who have been suicidal, acutely suicidal as a result of their mental illnesses, as somebody who's actually written a text on assessment of suicide, and as someone who has had a beloved family member die of suicide. And I come at it from all those different perspectives. Suicide is not the same as physician-assisted dying. The American Association of Suicidology, for example, has listed 15 different ways that physician-assisted aid in dying is different than suicide. And they conclude something like suicide and physician aid in dying, which is the American phrase that they use, are conceptually, medically, and legally different phenomenon. In MAID, there is a very careful and comprehensive assessment made of a person's emotional and cognitive state. Senator Gold earlier talked about some of the cognitive and emotional factors in a major depression. Yes, absolutely, those things can happen. And it is the duty and the skill set of the assessor to ensure that that MAID is not the same thing as a wish to die by suicide. It is part of the competencies of the assessor, and we have to trust that the assessor can do their work. They're trained to do that. I did that my whole professional career, and other people are trained to do that. In a MAID assessment, we have a stepped process. All issues of the person's life are considered. Families and friends are very often involved in the decision, and a very thorough analysis of suicide intent, which is different than ideation. Ideation is very common. Intent is much less so. A suicide intent is analyzed and it's involved. And, that is so different than suicide. Suicide is a lonely act. It's often impulsive. It usually occurs in times of great emotional anguish. And it doesn't have a sober second thought as part of it. MAID does have this sober second thought worked into it. Suicide, when it occurs, causes great distress to family and friends. It leaves very little, and I'm talking from personal experience, it leaves very little peace to those who are left behind. People are left with guilt. They're left with self-blame. Then that kind of negative emotional experience, if you have experienced a suicide in your family or of a close friend, that lasts with you a lifetime. MAID is different. People have decided to die. They are often with their families. They're often with their friends. The decision is made. They can discuss this decision. They can say goodbye. Over and over and over again, I have sat with families of young people, older people, elderly people who have chosen to take their lives for a variety of different reasons. And
Sorry to interrupt you again, Senator Kutcher. We still have 3 senators who would like to ask questions. Are you asking for another 5 minutes?
if it pleases the Senate.
Is leave granted, colleagues? Please go on.
Over and over again, what I hear from people is we never had a chance to say goodbye.